Good evening, ladies and gentlemen. Welcome to tonight's meeting of the Committee of Adjustments. This is the meeting to consider applications for minor variance and consents held under the authority of the Planning Act of Ontario. Please keep in mind the intent of this process is to review the proposal that is before us, listen to the evidence, and then make a decision. This process is not intended to be used to resolve any concerns or disputes that may exist between the town, individuals, or organizations. If a request for a deferral is made and the committee grants such a request, the committee, after consultation with the Secretary-Treasurer, will set a new hearing date. No further notice will be provided unless there are changes to the application. In order to conduct an effective and efficient hearing, we have adopted the following process. The owner and authorized agent will be given the opportunity, if so desired, to briefly explain to us the application and answer any questions that may arise out of the hearing. A maximum of 5 minutes will be provided for this presentation. You need to state your full name and address for the record. Any materials submitted to the committee for viewing will remain the property of this committee. Any submissions beyond the 5 minutes will be at the discretion of the committee. All persons attending the hearing who wish to support or oppose the application must also state their name and address for the record, and a maximum of 5 minutes will be provided for them to make their presentation. All remarks and questions are to be directed to the chairperson of the committee. Any submissions beyond the 5 minutes will also be at the discretion of the committee. If there are several speakers sharing the same view, we ask you that you select a spokesperson to represent the group's opinion. We want to hear the views of everyone present. However, covering the same points will not advance your case. The owner or agent will then be provided with a further 5 minutes to respond to comments made by any interested parties, answer any questions from the committee members. And then the owner or agent, if they do have any concerns found in staff reports, particularly with any proposed conditions, at this point they will have the opportunity to advise us of so. The matter will then be taken into committee for a decision, and this will mark the end of all discussions. Once the committee makes an oral decision, any person desiring a copy must file with the Secretary-Treasurer at the meeting a written request for notice of this decision. A green sheet is provided for this purpose in the back of the room. Please note that you must make a written request in order to be included on the list that is used by the local planning appeal tribunal for the giving of any subsequent notice of any appeal. Written notice of the committee's decision will be mailed no later than 10 days for minor variances and 15 days for consent applications to the applicant, the owner, agent, or any other person who has filed a written request for such a notice. If you do not agree with the committee's decision, you may appeal this to the local planning appeal tribunal, and the last day to appeal the decision to the local planning appeal tribunal will be noted on the decision. If no appeal is received within the prescribed time frame, the decision of the committee becomes final and binding, and the Secretary-Treasurer will then notify the applicant through written correspondence. People attending this committee meeting are to be courteous to and respectful of the members of the committee, town staff, and other people in attendance tonight. Tonight's meeting will be video recorded and available for future viewing on the town's YouTube channel. We do ask that you maintain your cellular phones off or at silent mode during this meeting, as they do interfere with the audio system. Thank you. Regrets this evening. I'm not sure, Mr. Talowski might be running late, so we won't put him down as regrets, but for now. Are there any declaration of pecuniary interests for tonight's meeting? I see none. Thank you. Requests for deferral, withdrawal of an application, I'll take them now if there are any. Good evening.
Good evening, Madam Chair. For the record, my name is David Capper with Glenn Schnorr & Associates. Our mailing address is 10 Kingsbridge Garden Circle, Mississauga, Ontario, L5R 3K6. And I'm here this evening on behalf of Rick Metalgen from Strickland Metalgen Design, seeking a deferral of CAV 075/2018, municipal address 2098 Glen Forest Drive. The request for the deferral is in order to respond to negative staff comments that were received late last week.
Very well. Thank you, Mr. Capper. Committee members, the request for a deferral to work on the the application with town staff, seeing as though that they were not in agreement. Are there any questions of Mr. Capper at this time? Okay, all those in support of a deferral? Thank you, Mr. Capper. Your
Thank you very
application has
much.
been deferred. Anyone else requiring a deferral or withdrawal at this time? I see none. Thank you. We will now proceed to the first item on our agenda, which is CAV 071 of 2018 at 368 4th line.
Good evening.
Good evening.
Madam Chair, my name is Cleo Isaias. I'm with Padlock Studio. I'm the agent for the owner.
Thank you, Mr. Isaias. Let me canvass the room for people in attendance for your application. Who is here for application CAV 071 of 2018 at 368 4th line? I see none. Your application is for a one-story new construction. We have done our site visits and we're familiar with your application. Are there any questions of Mr. Isaias at this time or clarifications? See none. Mr. Isaias, is there anything that you'd like to share with us about your application other than what we've been given? Our bylaw does allow us to forego with the presentation. If you have nothing further to say, we can take this matter into committee.
I don't have anything further, Madam Chair. The only thing is we canvass the neighborhood, and I do have a couple of letters in support.
Very well. You can hand those over to the Secretary Treasurer, and they will go on record. You're satisfied with the condition that staff put in the report?
Yes.
Okay. Members, I'm in your hands. If there are no items of clarification, Mr. Isaias is giving us the all thumbs up to take this into committee.
Madam Chair, having conducted my site visit, reviewed the applicant's written submission as well as the town's written staff report, which I know that the staff is in support. Also taking into account that the applicant presented two letters, I believe. I didn't see them. What is it?
Yes,
two
on
letters
either
of
side,
support?
yeah.
Yeah, 2 letters of support from the public, and noting that there were no written or oral objections to this. I'm prepared to make a motion to accept this variance as presented, finding that it does meet the 4 tests under the Planning Act, and making it subject to, bear with me, I'll make it subject to our two standard conditions. One, that that this approval will expire 2 years from the date of this date if the proposed development does not proceed or a building permit is not issued, and subject further to the condition the proposed dwelling be constructed in general accordance with the drawings as submitted.
Very well. Thank you, Mr. Charlebois. Is there a discussion on this recommendation? I see none. All those in support? Okay, your application has been approved, sir. Thank you.
Thank you.
Application CAV 072 of 2018 at corner of Post Road and Threshing Mill Boulevard. This is the Halton District School Board. Hello.
Good evening, Madam Chair.
Good evening.
My name is Priscilla Lattiser with Hossack and Associate Architects on behalf of the Halton District School Board.
Thank you very much. Now, this is the construction of the new elementary school, and staff is proposing the condition that proposed development be constructed in accordance with the satisfaction of the Director of Planning and, of course, approval of site planning. Is there anything you'd like to add or share with us at this time?
There is not.
Okay, thank you. Are there any questions of Ms. I'm sorry.
Lattiser.
Sorry, thank you. At this time? No, there are none. If you're satisfied with the condition, then we can take... Oh yeah, I did forget to do that. Let me canvass for the audience. Is there anyone here in specific for application 072-2018 at corner of Post Road and Threshing Mill Boulevard? This is the development of the new elementary school. I see none. There is none. Ready for a motion? Mr. Hardcastle?
Thank you, Madam Chair. Having undertaken my site visit, reviewed the materials, and noting that there are no members of the public present or written submissions provided with respect to this matter, I'll put forward a motion of approval finding that the requested variance conforms to the four tests of the Act. The approval would be contingent upon two conditions, the first being that the proposed development be constructed in general accordance with the final approved site plan to the satisfaction of the Director of Planning, and the second that the approval will expire within 2 years of the date of the decision if a permit has not been issued.
Very well, thank you, Mr. Hardcastle. Is there discussion on this recommendation? All those in support? The application has been approved. Thank you.
Thank you very much.
Okay, this is application CAV 073 at 1391 Green Ridge Circle. Good evening.
Good evening, Madam Chair. Dan Witten, 58 Conrad Place, on behalf of Daryl Porter at 1391 Green Ridge Circle.
Thank you, Mr. Witten. Let me canvass the room to see if there's anyone here in interest for your application. CAV 073 2018 at 1391 Green Ridge Circle. I see none. This is an application for an addition to a sunroom addition to an existing dwelling. We have done our site visits. We are familiar with your application, and as I mentioned previously, our bylaw does allow us to forego the presentation if you are nothing further to add or there are no clarifications from committee members. So this is your moment. If you have anything to add, please feel free to do so.
I agree with staff comments that have been made.
Very well, thank you. Are there any questions of Mr. Witten at this time? I see none. If you're comfortable with the conditions, we can take the matter into committee.
I am.
Okay, thank you very much. So it's now in committee. Mr. Charlebois, thank you.
Yes, Madam Chair. Again, having conducted my site visit, reviewed the applicant's written submission as well as the town's written staff report, which again, I note that staff is in support. And taking into account that there are no questions or submissions from the public and no written or oral objections or support from the public, I'm prepared to make a motion to accept this particular variance as presented, finding it does meet the four tests under the Planning Act, making it subject to two conditions: that the proposed addition be constructed in general accordance with the plans as submitted, and further that the condition that the approval will expire 2 years from the date of this decision if a building permit's not issued.
Mr. Charlebois, is there a discussion on this recommendation? I see none. All those in support? Your application has been approved, sir. Thank you.
Thank you.
Application CAV 074 at 304 Poplar Drive. Good evening.
Good evening, Madam Chair and committee members. My name is Dylan Dewsbury and I'm from Design Plan Services, located at 900 The East Mall in Etobicoke, and I'm here representing the owners of 304 Poplar Drive.
Thank you, Mr. Dewsbury. If you give me a moment to canvass the room, CAV 074 2018 at 304 Poplar Drive. Is there anyone here in attendance for this application? I see none. Thank you. This is an application for a two-story home, a new development on Poplar Drive. Is there anything further that you'd like to add to the application?
No, Madam Chair, we agree with the analysis and outcomes of the staff report.
Perfect. And staff are in support of your application. Members, are there any questions of Mr. Dewsbury at this time? Any items of clarification? If you're comfortable and satisfied with the condition that staff has submitted in your report, for your plans to be submitted as per January 2018, then we can take this matter into committee.
Yes, thank you.
Thank you. I appreciate that. Members, Mr. Hardcastle, thank you.
Thank you, Madam Chair. Having reviewed the materials, including the staff report and undertaken a site visit, I'm satisfied that the requested variances conform to the four tests of the Act. And as such, I'll put forward a motion of approval, subject to two conditions. First being that the proposed dwelling be constructed in general accordance with the plans dated January 2018 as submitted. Second being that the approval will expire within 2 years of the date of the decision if a permit has not been issued. I would note that there were no members of the public present or written submissions received with respect to this matter. Thank you.
Thank you, Mr. Hardcastle. Is there discussion on this recommendation? I see none. All those in support? Okay, your application has been approved. Thank you.
Thank you, Madam Chair.
Application CAV 076 of 2018 at 154 Sable Street.
Good evening, Madam Chair, members of the committee. My name is Joris Kieran, Kieran Design in Oakville, and I'm the agent for the applicant.
Thank you, Mr. Kieran. Just give me a moment to canvass the room. Is there anyone here for application CAV 076 of 2018 at 154 Sable Street? I see none. Mr. Kieran, I have an application for lot coverage for a new development. Is there anything else that you'd like to add to the application? Staff is in accordance with your application. They are
In support.
Yes, thank you. They are in support of your application. Are there any questions of Mr. Kieran at this time? If you have nothing further to add, we're prepared to take the application into committee.
Yes.
Okay, thank you. Mr. Charlebois?
Yes, Madam Chair. Again, having conducted my site visit, reviewed the applicant's written submission, as well as the town's written staff report, which the town is in support, and noting that there were no questions, submissions, written or oral objections or support from the public this evening, I'm prepared to make a motion to approve these variances as presented, subject to two conditions: that the proposed dwelling be constructed in general accordance with the plans dated April 27, 2018 as submitted, and subject further to the condition this approval will expire within 2 years from the date of this decision if the proposed development does not proceed or a building permit is not issued.
Very well, thank you, Mr. Charlebois. Are there any discussion, is there any discussion on this recommendation? I see none, thank you. All those in support? Okay, your application has been approved. Thank you.
Thank you.
CAV 077 of 2018 at 1194 Sterling Drive. Good evening.
Thank you, Madam Chair. Last name Baker, first initial D, Weirfolds LLP. On behalf of the owners of the property, Michael Sullivan and Maggie DiPied.
Very well, thank you, Ms. Baker. Is there anyone here for CAV 077 of 2018 at 1194 Sterling Drive? You are here in opposition or in support, sir? Very well, thank you. Ms. Baker will have you do your presentation, and then we'll give the neighbor a chance to voice their concerns.
Thank you. So, Madam Chair, this has been an ongoing matter with respect to a side yard setback, and as it's technically a rear yard setback, but it functions as a side yard setback. And it's an ongoing matter associated with an easement, a portion of which is, the issue is wholly unrelated to what we are here before you. I'll just put a drawing, if we could dim the lights, please, or sorry, a photo of the property. If we could dim the lights, please. And this is a picture of the front elevation. And on this, and on this side, that is the side yard, what is technically the rear yard, but what functions as the side yard. And we can see that it functions as the side yard. The elevation, the front elevation of the house fronts onto Sterling. It's a corner lot. And as in many corner lot situations, the shortest frontage is along Wolfdale, which technically by bylaw definition makes that side yard setback the rear yard, which is why the question is the 10.5 meter setback is the number by which you've been asked to measure the variance. In December of this year, a council passed a resolution, sub B, here, and talks to that subject to the conditions of below, the town enter into an encroachment agreement in a form satisfactory to the town solicitor and director of development of engineering for the cost of preparing the easement, including fees, for the portion of the carport, now garage, built into the town easement, and then subject to a number of conditions. They obtain a building permit. They obtain this minor variance that we've come forward to, and that the garage does not interfere with the electrical service to 114 Wolfdale. So in order to satisfy item number 1, we have to get our variances for item number 2, and we have to do all of that before we can get the encroachment agreement with the town. So here we are requesting the encroachment agreement. So to our surprise, we get comments that suggest that the encroachment agreement, that the variance is not going to be permitted. So I'm limiting my comments, given the small amount of time, to variance number 3. We agree that variances 1 and 2, with staff's position on variances 1 and 2. We're here to talk about variance number 3, and staff have taken the position that for some reason it now cannot be supported. And I want to give you a bit of a background. The carport, the garage is built exactly on the carport. So to construct the garage, they put drywall between the existing carport pillars. The carport was the subject of a building permit back in 1992 and was signed off by the town. My clients purchased the property in 2012 and converted the garage in 2014. And I have copies of these surveys for you if you would like. But in 2010, and the town staff have all of these documents, and I was surprised that they were not included in the submissions, but in 2010, prior to my client purchasing the property, you can see that the carport, if we could zoom in please, that the carport was built with a setback here of 1.74 meters. There is no request for a change. We're asking for this to be 1.74. In 2010, it was 1.74, and this was all approved by the town under a building permit in 1992. So all my client did was fill in the pillars associated with that existing carport. There is no further encroachment into the easement, and we were advised if there wasn't any further encroachment into the easement that there would be no concern with the variance. We're also, and that encroachment has been there since, as I mentioned, 1992. And you can see that there was in 2010 a further encroachment with a shed, all of which, and town staff have been on this property on numerous occasions. There is, and I'm going to say, an allegation that there are hydro wires through this. We have had locates done. They demonstrate that there are, in fact, no hydro wires going through this portion of it, and that will be subject to separate litigation altogether at a later date. But this carport, this encroachment has been here since 1992, and not one person has ever suggested that there's been any interruption with the hydro services of any wire that may be located in that easement. And you'll note in the comments from staff, functionally, they take no issue with the variance itself from a land use planning perspective, because that's what is actually before you. And I liken this to, for example, an application that requires a heritage permit or an application that requires a conservation halton permit. That happens all the time. Variances can be granted subject to the entering into an encroachment agreement. Variances can be granted subject to a number of conditions. And if they don't get their hydro permit, or sorry, if they don't get their conservation halton permit or they don't get a heritage permit, then the variance doesn't kick in. Our concern lies is that if we're turned down on the basis of an encroachment agreement for which we clearly, since 2010, well, we know since before my clients moved in here, has existed, we think that would be improper to use this process to turn it down when you have no evidence before you as it relates to the issues of the encroachment, because that will be the subject of further litigation. So it's our submission that in fact, the carport, the garage, where it currently exists, is minor, is desirable, meets the intent and purpose of the official plan, because in fact there is no issue of the adequacy of the utilities, which is the policy in the official plan, and meets the intent and purpose of the zoning bylaw, because you will also note that the amenity spaces actually functions over here as opposed to here, which doesn't function in any way, shape, or form as the rear yard setback.
Thank you, Ms. Baker. Are there any questions of Ms. Baker at this time? Mr. Charlebois?
Ms. Baker, can you just throw that up? Just confirm for me again where the hydro easement is.
So the hydro easement they're telling us is a statutory easement. Mm-hmm. There is a easement in the favor of the town, which would be this measurement here, a 10-foot easement. So it actually, portions of the carport have always sat in there. Portions of the house sit in there, all of which were approved by the building permit. Right. Hydro is saying that there's a statutory easement that they're saying is 6 feet. So this would be 10 feet. They're saying it's 6 feet would be the statutory easement. One thing that this survey doesn't show, but other materials that the town have, shows that there are actually 150-year-old trees in here, and which is why, and actually one of them fell in one of the recent windstorms, and the stump was augured out. There were no wires found in any part of that. So they're saying there would be a statutory easement somewhere within that 10 feet. Problem is the way a statutory easement works under legislation is it only exists if the wires are there. We have no evidence that the wires are there, which is why there'll be ongoing litigation in that respect. But at the end of the day, the elements of the carport all along here have been here for a long period of time with the permission of the town. And
could you brought up a document that council had voted on at one time. Can you just refresh that for me?
Sure, of course.
When did that happen?
So this is the minutes of the meeting on the 18th day of December in 2017.
And in there, council agreed to permit this subject to an encroachment agreement in a form satisfactory to the da-da-da-da.
Right, and so this is the council report. This is the minutes of that meeting. Mm-hmm. There were a number of matters that were brought before council. The one that's pertaining to this is sub B, and the carried demonstrates that right. Recommendation was approved.
Okay. And our staff report simply states, actually, I'm probably going to direct this more at planning because I agree with Ms. Baker. It seems to hinge upon Oakville Hydro. I noticed that their comment in here is Oakville Hydro will not support any variance that would encroach on an existing Oakville Hydro easement. That sounds to me like a bit of a canned phrase. So I guess my question for you is, sirs, do you know if Oakville Hydro did anything with respect to this particular variance or this application, or basically just gave you their canned phrase?
Through you, Madam Chair, I wasn't the one that was working on the comments for this one. I believe that through its circulation to Oakville Hydro, this was just simply their response. The staff were then able to take that forward and provide the recommendation to committee.
Are there any further questions, Ms. Baker, at this time? Okay, Ms. Baker, we'll invite you to sit down for a moment while the neighbor addresses the committee.
Thank you.
evening,
Thank
sir.
you, Madam Chair and committee members. I do actually have some materials I would like to hand out in case they come in handy.
Sure, let's start with your name and address for the record.
Certainly. For the record, my name is Richard Van Nest at 114 Wolfdale Avenue in Oakville. I am the neighbor directly south of the subject location at 114 Wolfdale Avenue.
Thank you.
This application concerns me because the garage is encroaching on an easement that, among other things, protects the Oakville hydro service to our home. It has been noted in the staff report regarding variance 3 that Oakville Hydro are not supportive of any variance that would result in encroachment. And I take a bit of offense at the characterization as of a canned response. This is, as Councillor was referring to, a continuation of an existing situation that is nearby but unrelated to this particular thing. There has been exhaustive legal and back and forth with Oakville Hydro regarding this easement. They have already challenged the existence of the easement, the existence of the hydro line, and been denied a removal or release from the easement. Why they're here asking again for the same thing, I don't know, but it's related. In 1992, the builders of this home were granted a carport because it was decided a single post would not actually create a major encroachment. It was decided the side wall of the home was allowed to abut the easement. No encroachment agreement was ever formed for the house. That is what Town Council had directed. But if you look at the site diagram provided by the applicants, you'll see this easement, and you were asking where this is. This is resulting in a 1.3 meter encroachment into a 3 meter encroachment. This is not a matter of inches here. Now, the staff report that previously this was a carport, and that was approved, but as they've noticed, they have filled this in without applying for any permits. Now, if you look at the bottom of this page, you'll see a circle. In that circle, the Sullivans also built, without permits, an amenity complex with deck, pool, and change room, which is also encroaching on the easement. The Sullivans have already been directed by council to remove the complex and have been defying that order, so are now in fact facing a court order to comply. I've attached correspondence with the town solicitor confirming the situation for your reference. Since the Sullivans, through their legal representative, have in the past argued the existence of the easement, I've included a copy of the easement in your package, 3 pages, where it's very clear that there are no structures permitted on it. It is there, among other things, to protect power that's running through it. Now, what has been a little bit annoying has been the argument in front of council that there was no power running through the easement. In fact, they are in possession of a locate report because they ordered it in September 2017, which clearly identifies the existence of the power, how close it is to the garage structure, and it's there. There is a picture in your report of exactly how close the hydro line is to the wall of the garage. You'll see the orange pylon. That marks the area of the hydro. The next page is the diagram and schematic from the engineer locating the power. So they had somebody locate the power, sent a report, here's the power. And since then they've been arguing there's no power. They're privy to the report, they're sitting on the report. The town is sitting on the report. Oakville Hydro is sitting on the report. Now, this was put in front of Town Council in December 18th, 2017, and carrying it, the Community Service Committee report from December the 11th, specifically indicating that the electrical service should not be affected. This is relevant as they keep asking for this same thing and they haven't gotten it. They've asked us to move the hydro. We don't want to move the hydro. We live in a 150-year-old plus house. We've lived there for 25 years. We have extensive landscaping. It's a very old home with extensive gardens, walls. We don't want to do that. We don't feel we should be forced to do that. Therefore, Oakville Hydro is simply saying, no, the easement has to stay there. As a result, we're looking at this variance number 3, and we agree with the staff report. It's not minor, it's not desirable, has negative effect, clearly does not require, meet the required criteria or intent of the plan, and the application should not be supported.
I do have some
Is
questions.
there any questions of Mr. Van Nest?
Sure.
Wow, thanks for coming in. I would have loved to have read all of this before coming in here. I'm going to just take you through a couple of things just to help clarify it with me. You two are not, that's bad grammar, I apologize. With respect to variance 1 and 2, you have no comment, no objection.
No.
So it all has to do with variance 3. And I'm not going to try and lead you, but I'm going to ask this question. Is it with respect to the garage encroaching, or is it with respect to the fact that it could interfere with the hydro? Is that your concern? So let me ask it a different way. If it didn't interfere with the hydro at all, and you knew it didn't, and you were confident that it didn't, would you be okay with the garage?
Okay, I'll go a step further. I actually, the only problem I have with the garage is the neighbor's continued insistence that the easement shouldn't be there and trying to get it lifted. The easement is there for a reason. It's been there for a long time. Hydro's been there for a long time.
Right.
We don't want it disturbed. They've built twice now without permits all over it, not getting variances, now all of a sudden, let's get a variance. Oh, it's on an easement. Oh, we should move the easement. It's the wrong way around. Now, they're currently in defiance of court orders to change the amenity complex that's completely covering the easement.
Right.
Why would I believe they would do anything other than ignore this, defy this, and et cetera? So why would I not object to this being on the same easement?
There's no reason for you not to object, and I don't have an answer for you on that question. I'm just trying to get down to where the real problem is for us anyway in terms of this committee. One of the things I am confused about is that, again, there was a presentation by the applicant of a committee meeting. Did you happen to be at that committee meeting, sir? And in that committee meeting, it states you have to get a building, I'm paraphrasing, but you have to get a building permit, you have to get a variance, and you have to prove that the power, the electrical power is not being impacted.
The committee resolution was, number 1, that the easement would not be lifted.
Okay.
Therefore, the amenity complex, which is at the back of the property, including a pool, therefore, it would have to be removed.
Yeah, and you've provided
Number
a
2,
letter from the legal.
That the town should enter into an encroachment agreement regarding the house because it is bordering right on it. And everyone said, it's okay, it's fine, it's 6 inches, drive on. That was never codified in an encroachment agreement. So they've asked the town to come to that encroachment agreement and figure it out. And recognizing that what was a carport is now a garage, they need a building permit that is acceptable, and they need to achieve this variance. But to get the building permit, they need this variance. To get this variance, they have to prove that they're not negatively impacting anything around it, and they are. They're negatively impacting the easement. So if the garage was 1 3/4 meters narrower, this would be a non-issue.
It's not unheard of for variances to be granted into easements, but usually it's done with the support of whoever has the particular easement, or they've come forward and said it's okay, you can do it. All right, that's all I have right now.
Any further questions of Mr. Van Nest? See none. Thank you, sir. We appreciate your submissions. Is there anyone else that would like to address the committee? I see none. Okay. Ms. Baker, we'll have you respond. There are some questions of clarification.
Sure.
I mean, I know you have your own set of notes that you'd like to respond to Mr. Van Nest.
Sure.
But perhaps you can start off by commenting on the notion that all these buildings, in terms of the pool and all of that, happened without a permit.
So we're not here, so the pool and amenity complex is an entirely separate issue altogether. The idea that there is a court order requiring their removal is factually incorrect. There was an order to comply at one point. We've been to court. We've settled on that. But there is no outstanding court order to remove the pool and the deck. So that's factually incorrect.
The pool and the deck are still on the easement as it's drawn in the lines,
They
correct?
are as of today.
So comment on where do you stand with that?
Well, I imagine that will continue to be the subject of further litigation,
Okay.
right? I would imagine, but there is no court order right now. I'm just saying, I can well imagine
Will that
that.
be part of what you factor into the agreement that you're seeking to enter into with the town?
No, it's entirely separate. So the variances that are before you are entirely separate from that. The encroachment agreement as it relates to the pool and deck are entirely separate from that. And the matter that was before council in December, I know the neighbor indicated that it was only as it relates to the house. It was not. As I indicated before, there was A, and I was pointing to B sub A, which was on the same page. If I could get the overhead, please. Sub A is specific to the house. You'll see for the portion of the home built within the town easement in and around 1992, and sub B is specific with the carport and the garage. There is nothing before you as it relates to the pool and the deck. That's an entirely separate issue, and I think everybody would want that kept as a separate issue because it's on a whole different world. The second issue is this allegation that we're somehow sitting on locates that show wires in there is also factually incorrect. This is the formal locates that we have in 2017 from Hydro. The neighbor is suggesting that there are hydro wires that extend from front to back. That's his property here, my client's property here. The locates only show hydro going into my client's house. That's very common in people's houses. They do not show hydro going from front to back. These are not in any way, shape, or form impacted by the carport at 1.74 meters or the garage. It's also factually incorrect to say that the carport was only one post in the easement back from when town gave approval of the carport. Of course, we know that wouldn't hold up any sort of carport. That has been in there. That has been in there. And in fact, there may be one or two more in the middle, which would make sense in terms of holding up a carport. That all has existed since the carport was constructed. And again, you have no evidence from 1992 to today that there has been any interference with any hydro wire, with any hydro lines.
Okay.
And Madam Chair, I can say this with great certainty. I can show you the pictures. There is easy access in here. And I can also assure you that whether or not like the carport, the garage would have to come down. The carport would have to come down. The carport that's been approved by staff, if there's some suggestion that they can't somehow access it. There was no new floor slab constructed. It was the adding of drywall between posts. So if there's a concern that the carport floor, the garage floor now sits over the easement, it does not. It has always been that way. And there are massive massive trees in here, you're not accessing any, even if there were wires in here, you would not be accessing to repair them from the surface. It would be all directionally bored. It would all have to be directionally bored given the existence of the trees. So we're just actually asking, frankly, to legalize an existing condition with the fact that it was drywalled in between existing posts, and to allow, to ask that this committee allow that the any issue of a statutory easement be dealt with in the appropriate forum. And to that point, I note that the neighbor, and I recognize and I actually appreciate his frankness, that his only problem with the garage is the neighbor's insistence, my client's insistence, that the easement should be lifted. I am not here requesting that any easement be lifted. We asked council to do that. Council declined to do that. We're not asking for that easement to be lifted. When council declined to lift the easement, that's when they substituted in the encroachment agreement. So we're not asking you, so if that is his only concern with this garage, I can assure you we are not asking for the easement to be lifted. We're not asking for you to somehow make a determination that the easement should be lifted.
So take me through this. If you enter into an encroachment agreement with the town and you do get this variance, then the next step is to get Oakville Hydro on board because they're not supportive, or how do you see this playing?
So in this instance, if the variance is permitted in this regard, then we have to get the encroachment agreement. And presumably, if Oakville Hydro is not on board, we're not going to get the encroachment agreement, and this variance is going to be of no use. We're going to have to take down a carport that the town has already approved, and that will have litigation associated with it as well, right? Because they're suggesting that these wires have been in there all that time, and so that would have its associated litigation. But we would have to; it would all be wrapped up in the encroachment agreement.
Okay. Are there any further questions of Ms. Baker?
Ms. Baker, I'm not going to be asking you for your opinion, but I just need to ask this particular question. You presented a document where obviously council supported this subject to 3 conditions, and yet I've got a written staff report that neglects to even mention that from council, and basically says they're not in support. Do you want to just comment on that particular issue, why I would have council saying maybe and staff saying no?
Sir, through you, Madam Chair, I can say it in my general experience as a municipal lawyer that staff and council don't always speak with the same voice. I think we all have experience with that, where planning reports have gone forward, you know, with a recommendation one way, and councils have made decisions another way. I can only surmise that frankly is the position. I have no, all I have is this from council. I have nothing from that says there was a reconsideration vote or anything to the like. So I can't go in. I don't know if maybe the person who was doing the comments was fully aware of everything. I don't want to make any suggestions that anyone was trying to be misleading. I can just give you the information that I have.
And I just wanted to make sure there was nothing you wanted to add to that.
Thank you, Mr. Charlebois. Any further questions? Ms. Baker, if you have nothing further to add, we can take this matter into committee.
Thank you, Madam Chair.
Thank you. Gentlemen, I'll give you a moment.
Madam Chair, I'll give this one a go.
Go ahead, Mr. Charlebois, go ahead.
Just going through my preliminary preamble here about conducting my site visit and certainly reviewing the written submission as well as the town's written staff report. I do note that staff are in support of variance number 1 and variance number 2. They seem to be in support of variance number 3 in many aspects, but end up denying it on the basis of this hydro easement argument, which we've heard this evening. And we've had a very excellent presentation by the neighbor, and he's raised a series of points, which again I note that Ms. Baker has addressed in some respects. I'm a little perturbed and confused, I guess, with respect to this evidence being presented to us here at the meeting of council being in seemingly support of trying to do an encroachment agreement here, and yet the staff report being silent on the issue. There seems to be an awful lot of evidence being presented here that's relatively new to us. Some of it is quite technical in nature, and perhaps even legal in nature. Sounds like there are a variety of different potential lawsuits brewing underneath the surface here. I think at the end of the day, from my point of view, in terms of being presented with something like this, is in looking at this particular thing, I think, in my opinion, that there are way too many unanswered questions still here that have not been dealt with satisfactorily, at least from the town's point of view, and I think from council's point of view. So as my experts in this area, I find myself disinclined to understand their position. They seem to be in conflict. When I look at the neighbors' comments with respect to this thing, and I see them as being truthful as much as I do see Ms. Baker's as being truthful too. The problem that I have is that I have two truthful applicants or two truthful people in here presenting me evidence, and I don't understand which one is correct, and I can't rely on staff here in this particular comment. So I'm going to stop ambling and say I think that this particular variance is not ready to be presented to this committee, and as such, I'm going to make a motion to deny it.
Is there discussion on this recommendation? Mr. Hardcastle?
Yeah, and thank you, Madam Chair. I won't go over the same points, which I share largely with my colleague. I just want to just underline those comments and indicate that I will support that motion.
Thank you, Mr. Hardcastle. I think we're all unanimous here. I too feel that we have not been privy to all the underlying discussions, and as such, it's unfair to be put in this position where we have to make a decision without all the pertinent information. I feel like we're being backdoored into starting the process on one route versus another. So I too support your recommendation. The motion on the table is to deny this application. All those in support? Okay, the application has been denied. Okay, the next application in our agenda tonight is application CAV 078 at 145 William Street. Oh, speaker. Okay.
Last name Baker, first initial D, on behalf of the property owner Dana Fencott.
Okay, who is here for application CAV 078 2018 for 145 William Street? Okay, I see none. Okay, once again, good evening, Ms. Baker. Staff are in support of this application. They do have a few conditions, given that it is a heritage property. Is there any further information that you'd like to share with us? We have done our site viz. We are familiar with the application.
No, I've, as with the previous application, comments and support from the neighbors have been forwarded to the committee. The neighbors on both sides and the townhouses to the rear, which front onto Robinson. Their letters of support weren't forwarded, but they were canvassed, and they're all in agreement. And we are supportive of the comments put forward by staff. And we understand that the matter is being put forward with a positive recommendation to Heritage Committee. We were advised we have to come to committee first before it goes to Heritage Committee, but there has been site visits with members of the Heritage Committee who have expressed no concerns.
Very well. Are there any questions of Ms. Baker at this time? Mr. Charlebois, go ahead.
I know I'm not picking on you, but I do have a question with respect to planning and staff, if you don't mind. In here it states that an accessory building cannot be used for human habitation or by occupation or whatever, the rest doesn't matter, it's the human habitation. And yet this particular accessory building is being designed for human habitation, but there's no comment. And I went through the zoning bylaw and I couldn't find a definition for habitation, and there was no comment in here about staff one way or the other. Am I just reading that wrong? This was in variance number 1, part 3, definitions B.
So, Mr. Charlebois, if I may assist at all,
You can pop in,
before
yeah.
Mr. Charles goes in there, that was a variance. Actually, we didn't believe we needed the definition as put forward by zoning staff. Said if it's not defined in the zoning bylaw, then we defer to the dictionary definition of habitation, and the dictionary definition of habitation makes reference to there being a dwelling unit. This is not proposed to be a dwelling unit. There's dwelling units are typically both kitchens and bathrooms. You'll see that express comment in the staff report that in fact this isn't a dwelling unit. That would be a zoning violation if it were a dwelling unit. Given that it hasn't crossed over into a dwelling unit, that it's a like studio space effectively, that it didn't raise the concerns with planning staff, given what its function is actually for. You know, we've said, okay, we'll go along to get along, notwithstanding that we don't actually, it's not our position that that variance is even required, but it is staff's and we need to get a building permit from them. So we did go to the dictionary definition of that, and habitation is where people live, where they dwell. This is not, they live and dwell in the house that's on the property.
Well, the variance request is to permit it to be used for human habitation. And that's the variance that's here. I just didn't understand what human habitation was.
And it is not defined in the zoning bylaw, which is why we end up in the situation that we're in, and so as an abundance of caution.
That's why you're asking for this variance?
That's correct.
Okay.
It was identified by staff as an abundance of caution in order to get the building permit.
Are you in agreement? Just
As usual, Ms. Baker is more eloquent than I am in these things.
okay. All right,
I'm going to take
thanks.
that as an agreement.
Any further questions of Ms. Baker? I see none. Okay. Are we prepared to take the matter into committee?
Yes, we agree with all of the conditions that are proposed.
Okay, perfect.
Thank you.
Thank you. Gentlemen, Mr. Hardcastle?
Thank you, Madam Chair. Having reviewed the materials, including undertaking a site visit and the words from Ms. Baker and staff, I believe that the accessory structure will not pose any negative impacts upon adjacent properties. is a good enhancement to the property and ultimately conforms to the variances conform to the four tests of the Act. I'll put forward a motion of approval, subject to 3 conditions. The first being that the proposed accessory building be constructed in general accordance with the plans dated April 10th, 2018 as submitted. The second being that the heritage permit receive approval from Oakville Council. The third being that the approval will expire within 2 years of the date of the decision if a building permit has not been issued. I would note that there were
We have letters on, yeah.
were a number of 2. Thank you. There were 2 letters of support received with respect to this matter. Thank you.
There's actually more than that, right? There's more than that. We have the other ones as well, the ones that are the emails. Okay, thank you, Mr. Hardcastle. Is there discussion on this recommendation? I see none. All those in support? The application has been approved. Application CAV 079 at 331 Shedden Avenue. Hi, Mr. Capper.
Thank you, Madam Chair. For the record, my name is David Capper with Glenn Schnorr & Associate. Our mailing address is 10 Kingsbridge Garden Circle, Mississauga, Ontario, L5R 3K6.
Thank you, Mr. Capper. Is there anyone here for application CAV 079 of 2018 at 331 Shedden Avenue? I see none. Okay. Your application for this building and has been approved by staff. They're in support. Is there, you can give us your presentation. You can do whatever you want to do. This is your time.
Through you, Madam Chair, I have prepared a presentation. I'm more than willing to go through it if the committee sees fit. Alternatively, I'm happy to answer any questions that you may have. Would ask if you're leaning a certain direction that you'd allow me an opportunity to make a presentation.
Gentlemen, are there any items of clarification of Mr. Capper at this time? Would you like him to proceed with the presentation? They're comfortable. Mr. Capper, you're familiar with the condition that's attached to, that town staff has attached to this application?
Through you, Madam Chair, we are, and we're amenable to the condition.
Very well, thank you. If there are no questions and Mr. Capper doesn't have anything further to add, we can take the matter into committee. Go ahead, Mr. Charlebois.
Did I jump on? Okay. Madam Chair, having conducted my site visit, reviewed the application, as well as the town's written staff report, noting the town is in support of this particular variance. Also taking into account that there's been no submissions from the public, written or oral, in objection or support, I'm prepared to make a motion that this particular variance be accepted as presented, finding that it does meet the 4 tests on the Planning Act, making it subject to the condition that the applicant receive approval from the Director of Planning Services for a revised site plan, and making further subject to the condition that the approval will expire 2 years from the date of this decision if the proposed development does not proceed or a building permit is not issued.
Thank you, Mr. Charlebois. Is there discussion on this recommendation? I see none. All those in support? Your application has been approved. Thank you, Mr. Capper.
Thank you very much. Have a good night.
Our final application of the evening was deferred from March 13th, CAV 045 of 2018 at 288 William Street. Good evening.
Good evening, Madam Chair. For the record, my name is Christoph Olak of OM Architecture. Mailing address 2078 William O'Connell Boulevard, Burlington.
Thank you, Mr. Olak. Is there anyone here for application CAV 045 of 2018 at 288 William Street? Okay, I see none. Are you here for a certain application perhaps that you missed, or you're just here observing? Okay, fabulous. Thank you. Mr. Olak, the floor is yours. Your application was deferred from March 13th. We have the emails of support on hand. Are there any questions of Mr. Olak? this time. Sir, if you have anything further to add to your application, we're familiar with the application and with the staff recommendations, and they are in support. Are
Yes,
you familiar with the conditions that are?
Yes, I am. All I would like to add at this point is that we worked out very closely with the staff as well as with the Heritage Committee. I also have 9 letters of support from the neighborhood.
Very well, you can give them to the Secretary Treasurer. We will put those on record in addition to what we have already.
That's right. There you go.
Okay. If you are satisfied with the conditions and you're agreeable, we can take this matter into committee.
Yes, I am.
Thank
Please
you
go
very
ahead.
much. Mr. Who's willing to take, Mr. Hardcastle, go ahead. Thank you.
If I may make one question of staff quickly, I just note in reviewing the conditions associated with this that the first condition makes reference to the proposed accessory building being constructed in general accordance. I'm assuming that's a typographical error.
Through you, Madam Chair, I would agree.
Okay, thank you. On that basis,
Go ahead. Yes, Mr. Hardcastle, we're listening.
we're
We're just trying to type at the same time.
Yeah, I'm just confirming the dates on the provided drawings, which is consistent with the date shown here. So, Madam Chair, having undertaken my site visit, reviewed the materials, including the staff report and the letters of support provided by several neighbors. 1, 2, is that 6?
9.
5?
9.
9. Thank you.
Yes.
Numbers are not my thing. I'm prepared to put forward a motion of approval, finding that the requested variances conform to the 4 tests of the Act. The approval would be subject to 3 conditions. The first being that the proposed addition be constructed in general accordance with the plans dated April 18th, 2018 as submitted. The second being that the heritage permit receive approval from Oakville Town Council. And the third being that the approval will expire within 2 years of the date of the decision if a building permit has not been issued.
Very well. Thank you, Mr. Hardcastle. Is there discussion on this recommendation? Mr. Charlebois, go ahead.
Just want to add one thing to that. I noticed from the deferral documents that there was one letter of objection from a Duncan and Elizabeth Galloway dated March 18th. I just, it didn't show up in this follow-on document, so I just wanted to note that maybe they just dropped it or it didn't come forward, but having reviewed their particular objections, I do feel that that the revised application does meet many of their concerns, and their other concerns will be met through the development process.
Thank you, Mr. Charlebois.
If I may, through you, Madam Chair, I did talk to those neighbors. So basically, we explained them our position, so they are fully aware of what's happening.
Very well.
Can I add something? Because the revised notice was sent, so she never wrote in the next objection. So it was in previously the one done. So
right.
We haven't received any objection letter for this one.
Okay, so now that that's clarified and it's on record, the motion on the table is to approve the application as set before us with those 3 conditions. All those in support? Okay, your application has been approved.
Thank you very much.
Thank
Have
you.
a good night.
Good night. Okay, we have minutes, right? Yes. Okay. Gentlemen, we have minutes from May 8th. I was not here, so one of you has to move them.
Madam Chair?
Mr. Hardcastle moves the minutes. And then motion for adjournment.
Madam Chair?
Madam. Mr. Hardcastle again. We are adjourned at 8:10. Thank you.